Hello, welcome to the lecture series. I am Debadatta Bose. I'm a researcher at the University of Amsterdam, researching at the confluence of international law and private law on transnational corporate supply chain regulation from a legal theoretical perspective, which is also the focus of today's lecture. So without further ado, let's dive straight into it. So first, this is the lecture. We have it divided into three major components. First one is the historical context of the UN Guiding Principles on Business and Human Rights, which forms the international law on transnational corporate supply chain regulation. Then we'll look into what these guiding principles actually say. And then lastly, we will dive further into what are the legal implications of the UN Guiding Principles. So first, we look at the historical context. It is important because the UN Guiding Principles, as you can see, comes from a string of instruments that have been discussed and adopted at international fora much before the UN Guiding Principles got adopted. The UN Guiding Principles are also the basis of further actions that have been taken place. Important to understand is that the UN Guiding Principles are soft law and were adopted as a compromise to a prior stalemate, necessarily that of the UN draft norms, which was asserted as the proposal for a binding law, which gave corporations equivalent responsibility as regards states for human rights obligations. That did not fare well, as stalemate was inevitable. So the UN Guiding Principles process started with the appointment of the Special Representative of the Secretary General in 2003, which ultimately culminated in 2011 in the UN Guiding Principles. Now, this entire process of international discussions on business and human rights is dominated by the North-South divide, even in the UN treaty process in 2014, as you can see. So here we, let me move to this side, of course. So here, on your right-hand side, you can see the voting pattern for the resolution that was tabled to establish the group for elaborating a binding treaty. You can clearly see a North-South divide. So the North, generally, the global North, wants that investor protection be covered under international law, while the global South wants that regulation of transnational corporations as regards their human rights impacts happen under international law. But if you want to know more, of course, on the historical context and the debate behind business and human rights regulation, please refer to the additional material provided with this lecture. Now, we do have to move on to what the UN Guiding Principles actually say in this context. So even if it was a compromise, it was still unanimously adopted by the UN Human Rights Council. So to begin with, on your right, you can see what the UN Guiding Principles actually say. So those are Principles 3 and 11. I have elaborated for you. So the UN Guiding Principles have three pillars. So the first one is a legal obligation for states to protect from human rights abuses from third parties, necessarily transnational corporations. The second one is the corporate responsibility pillar, which is the most important for us today. This, however, is not a pillar that is based on legal responsibility. This pillar is based on social expectations. This is because the Special Representative of the Secretary General, John Ruggie, who authored the UN Guiding Principles, relied on the distinction between human rights and human rights law that Amartya Sen was also, so his theory basically stated that human rights are a subset of moral rights, and you cannot advance the test of the determination of human rights only by its significance or place in a legal document. Because the existence of human rights for him, nor its means of protection, promotion, or advancement depended on its presence in a catalog of legal rights. So this is about Pillar 2. Pillar 3 is on the access to justice through judicial and non-judicial mechanisms. So these are the three pillars. So they are comprehensive but independent. So each pillar exists separate but also together with the other pillars. So now coming on to pillar 2, you can see that pillar 2 in 13a and 13b, so this is the guiding principle 13a and 13b, these have 3 different types of relationships as regards corporate responsibility to protect human rights. The 13a is to avoid causing or contributing to adverse human rights impacts, and 13b is to seek to prevent or mitigate impacts that are directly linked to the operations, product, or services through business relationships. So you can see the scale on your left goes from cause, contribute to direct links. So if one goes from left to right, the responsibility becomes a little less stringent. So now we look at principle 22, again on your right, about remediation of adverse human rights impacts. Here you can see again the stringency for cases that fall under 13a. So where business enterprises identify that they have caused or contributed to adverse impacts, they should provide for or cooperate in the remediation of these impacts. So you can see that the cases under 13b do not fall under principle 22, which means that in cases of direct link, which is essentially the supply chain regulations in the UN Guiding Principles, they are not obliged to participate in remedy, although they may voluntarily do so. Now, all of these responsibility to respect human rights hinges on a very essential element of the UN Guiding Principles, that is human rights due diligence, which is provided in Principle 17, as you can see. So this is a process, which means the human rights due diligence is the means to the end of respecting human rights for corporate enterprises. This is a process which involves a 4-step structure, which is assessing actual and potential human rights impacts, as you can see in Principle 17, then integrating and acting upon the findings. So the business decisions have to take into account what the findings of the assessment are, then tracking the effectiveness and responses of whatever measures are being taken, and communicating to relevant stakeholders how these whatever measures are being taken. These are the 4 important elements of human rights due diligence, but we will come to corporate respect for human rights and human rights due diligence again in this section, where we have the discussion on what does law have to do with all of this. Because this, as we said, pillar 2 is essentially based on social expectations. Now, of course, then the role of law is challenged in literature. So a lot of literature says that the human rights responsibilities of corporations are not necessarily legal, they are more moral in nature, and therefore have very little to any legal repercussions. Otherwise, a lot of literature also focuses on remedies. So they say that insufficient access to remedy is the major problem, not necessarily the conduct of, not necessarily discussions on the conduct of corporations itself. So, for example, some literature defines vulnerability of people that are prone to being abused by corporations as against their human rights, is defined itself as the lack of remedies that plague them. So it is a question then of unremedied harm than improper conduct per se. So yeah, so then we come, of course, to see that these are different normative frameworks. So the primary framework of the literature that they analyze through is corrective justice. Now, corrective justice, of course, is a very popular framework in private law, which deals with the fact that that the defendant in private law violates a normative bond not with the world at large, but specifically with the person to whom the defendant owed the duty. This is in the words of Ernest Weinrib, one of the very prominent corrective justice scholars. So he says that the plaintiff does not step forward as a representative of the public interest. Now, the corrective justice, therefore, essentially considers two parties, no more, no less, both in the factual and in the normative sense. So this means that the unity of the single transaction of adjudication brings parties back to their original position. That is, it corrects harm, essentially speaking. So this harm-based conception is precisely what is the transactional nature of private law, but it kind of conflates the existence of a duty with the breach of a duty in some sense, because as one can say, having a law is not necessarily the same as that of going to court. One of the important ways you can understand this is the difference between the duty of care in private law and the responsibility to respect in the UN Guiding Principles. So just asking whether there is a duty of care is insufficient in itself unless you are also ascertaining the nature and quantum of damages that a defendant is liable for, because all of these determinations happen ex post, as opposed to the ex ante nature of the UN Guiding Principles on Business and Human Rights under its responsibility to respect. So in essence, corrective justice hinges the existence of a duty on the adjudication of its breach, which coming to relation, so I mean, we will go to relational justice in a while, and you can pause the video here if you want to read this quote from a case of the Canadian Supreme Court, a very important case in business and human rights, Nepson versus Araya. What this essentially says is that human rights abuses, even in private actions, are a bit different from the run-of-the-mill private law tort cases, for example, in negligence, because it requires a bit more than your typical tort claim, and it is of a public nature than existing torts. Here, symbolism is also crucial in human rights cases. Now, if one talks of relational justice, what does relational justice say, essentially? So relational justice is a theory that is propounded by Professor Dagon and Dorfman of the Tel Aviv University, where they say that private law is primarily a law of conduct between private persons, and remedy is a fallback plan. So remedy is not the pivot of private law relationships. What they say is that the terms of interpersonal relations that are set between parties is governed by private law, which essentially asks the questions, what are the terms of just relationships between persons? This is essentially determined by self-determination and substantive equality, which means that self-determination, in a sense, requires a bit more than independence, as regards, of course, not being subjected to someone else's choices. And it requires interpersonal accommodation in the sense that people are given the space and opportunity to live the life they are entitled to. These types of interactions, of course, require substantive equality as well, which means that the terms of interactions are not blind to the peculiarities and circumstances of people, which is their vulnerability, essentially, similar to how tort law accommodates certain constitutive elements of a plaintiff. Now, when we come to relational justice, this essentially means that private law is a law of the horizontality of norms. So there is not necessarily a norm separation between public law and private law. Public law is one where you have where it governs the vertical relationship between a state and citizen, and private law is the one where it governs the horizontal relations between two private persons, not necessarily in their relationship as citizens of a state. Which means that if you conceive of human rights law as in the state-citizen interaction, international human rights law, one might come to the conclusion that corporations are not bound by human rights law, but they still have to respect human rights as the just terms of interpersonal accommodation under relational justice. This is, of course, fitting very squarely with the UN Guiding Principles on Business and Human Rights as well. So these reflect the substantive core of private law. Now, what does this mean for what we learned under 13b, that is direct link or supply chain regulations? Well, the special representative of the Secretary General also used the term that relationship between corporate entities and human rights are governed by the web of activities and relationships, which means that they go beyond what is proximate to the company, that is not necessarily their immediate workers and surroundings. So this responsibility clearly includes suppliers where there is no legal control exercised by the corporation. So again, this web of relationships formation is not novel. Henry Schue, in his mediating duties work, of course, said, used this term where he said that responsibility sans causality arises in the globalized world where an interference with one strand of the web sends ripple effects across the farthest side. Now, what my research is also focusing on is whether the terms of a just relationship take into account the effects it has on setting the terms of other relationships. So for example, the terms of relationship between A and B, and what they have effects on the terms of relationship between B and C. So if A is a company, B is a supplier, and C are the employees of B. If the terms between A and B set effects on B and C such that B has to have certain dubious labor rights practices, then would the relationship between A and B be just because they are set bilaterally? One would say no, because it would not be a just relationship, as this justness would be illusory if it actually causes certain other relationships to be unjust. So the assertion here is that while adjudication may consider itself with two parties, the consideration for corporations to ensure the justness of relationships they produce through these interactions by way of business activities have to go much further, take into account the unjustness of vulnerabilities, and it may create for other interpersonal relationships. So yeah, and now we also see what human rights due diligence means in this context. It means that the process is a management of social risk arising from the operations of the company and its business relationships before the risks manifest itself to the company. So it is essentially ex ante, not ex post. So it is again, for those who are affected, it is a framework for the evaluation of the conduct of companies. So now what we may understand human rights due diligence as is one process where companies take into account the interests of other stakeholders while conducting it, and then bring those interests back into the boardroom. So the interests of stakeholders stand on an equal footing with the interests of the business itself. So not profit over people. So it translates viewpoints external to the organization and then internalizes them, those viewpoints into its decision-making process, which is again a process for respecting the dignity of rights and persons who the company would interact with through their business relationships. Thus, in this manner, you see that the corporation is made to not set the terms of just relationships unilaterally by imposing its own business decisions on another party. So here, in essence, they take into account the consideration of all relevant characteristics of persons external to corporate decision-making. And so this interaction of human rights due diligence also means that normative considerations that come out of the imbalance of parties are also taken into account in the relationship as to its importance in what makes the relationship just. So at a fundamental level, both human rights due diligence and relational justice have the same ends, that is to ensure respect for the rights and dignity of persons. Relational justice, as well as a code of conduct, we see it applies from all stages, as from ex ante possible creation of risk to the ex post materialization of the injury. So in a corporate context, it would be impossible to actually know the terms of just relationships without a process requirement in the form of human rights due diligence. Since otherwise, I mean, the creation of risk and terms of just interactions would remain indeterminate before a court adjudicates ex post, which we are not necessarily seeing reflected in the UN guiding principles. So there is no possibility of enabling a party to comply with the requirements of just relationships ex ante without knowing the terms required for the relationship to be just. So in essence, human rights due diligence as a consideration in the justness of relationships would be one where the persons potentially affected by human rights impacts gains authorship over the terms of interactions. Now, of course, we do see that this is not a safe harbor provision, which means that if you conduct human rights due diligence, you discharge all your obligations. That is not the case. Human rights due diligence, I am repeatedly referring to it as a process. So it is a means to the end of respect for human rights. So it is a relevant factor in determining whether you respect human rights or not, because you wouldn't know whether one respects human rights or not without the conducting of human rights due diligence. So this is a brief summary of how corporate transnational supply chains are reflected in law, in both at the confluence of international law and private law as regards its legal theoretical perspective. So I hope you have enjoyed this lecture. And of course, if you want to know further, there are additional materials attached to this lecture. And yes, see you in the next lecture, which will dive a bit more further into supply chains in the transnational corporate context.